Hello, and welcome to panel 2 of the 14th Annual South China Sea Conference. Today's panel will discuss legal developments and dispute resolution. My name is Indrika Natalagawa. I'm an associate fellow with the Southeast Asia program here at CSIS, and I will serve as your moderator today. And I'm gonna steal a line from my colleague Lily, who was the moderator of the previous session, and say that we have an all-star panel for you today. So on my right, we have Jay Batang Bakal, who is a professor and director of the Institute for Maritime Affairs and Law of the Sea at the University of the Philippines. We have Chi-Ting Tsai, associate professor with the Department of Political Science at National Taiwan University. We have Arisio Darmawan, who is a lecturer in international law at Universitas Indonesia. And we have Bic Tran, who is a postdoctoral fellow at the Lee Kuan Yew School of Public Policy at the National University of Singapore, and more importantly, an adjunct fellow with the CSIS Southeast Asia program. So I'm just going to interject here and say that this is my 6th South China Sea Conference as a staff member at CSIS, and panel 2 on legal developments is always my favorite because it's the one in which I learned the most. So thrilled to have this discussion today. A few ground rules. We'll be going for about an hour today. I'll have each panelist deliver roughly 10 minutes, 5 to 10 minutes of remarks, and then we can open the floor to questions. I'm conscious that we are the last thing standing between you and lunch, so we'll try to get things done promptly. And I'll note that once panelists have delivered all their remarks, folks in the room are welcome to head up to the microphones if they have questions. Members of our online audience can submit questions through the online Q&A box on the CSIS website. And everything here will be on the record. So with that, I'll turn it over to Jay to begin.
Good morning. Good morning. Thank you for inviting me again to the South China Sea Conference here at the CSIS. Now, the appearance of protesters earlier has really struck a nerve with me. Having worked on this issue for the past 25 years or so, I think I'm the only one in the room who's actually been on a boat, a small rubber boat, confronted by the China Coast Guard being warned away as we were trying to do a marine scientific survey near T2 Island, or Pag-asa Island as we call it. And I have probably also been the only one who has actually met with fishermen who live along the coast of Pangasinan and Zambales who have complained about the way that the China Coast Guard, China Maritime Militia have driven them off out of their fishing grounds. And they ask, especially during the previous administration, they would ask why the government was not doing anything against Chinese interference with their livelihoods. To this day, those fishermen are in contact with me, and I think of them when I thought of them when I heard the protesters earlier shouting, demanding that the United States not militarize the West Philippine Sea, and yet they say nothing about the absolute militarization that has gone on in the West Philippine Sea on account not only of the PLA Navy, but also because of the China Coast Guard and the Maritime Militia. Now, the past 6 months have been increasingly tense and provocative. We've seen increasingly tense and provocative confrontations between China and the Philippines, and they've centered around, as mentioned earlier, Second Thomas Shoal. 2 weeks ago, that dangerous turn was marked with a brutal attack upon Philippine vessels and personnel, clearly unprovoked because the Philippine vessels had already reached the BRP Sierra Madre and were just preparing to transfer personnel. These were small rubber boats, and were bringing only food supplies. Of course, they had armaments to protect themselves, but they were disassembled and kept in bags. They clearly did not expect the attack that was made upon them. It was clearly an armed attack with knives and spears and pickaxes, as you saw on videos that have been circulating. It was also unprovoked because when you see how the Philippine vessel was rammed by the Chinese rubber boat, leading to the loss of a finger of one of the personnel there. This clearly violated as well the sovereign immunity of Philippine Navy ships. It was brutal and excessive and contrary to international law. It cannot be characterized as anything other than the use of force against another state, given the status of the Philippine vessel and the personnel on board. From a broader perspective, it is also clearly the employment of coercion, contrary to the 1970 UN Friendly Relations Resolution 2625, which defined for the world certain limits for how countries should relate with each other, particularly to avoid the use of force and coercion. China's intention is clear, clearly manifested by these actions. It wants absolute control of the area within the 9-dash line. And this will result, this requires subjugation of the Philippines through its acquiescence, as revealed by its own sources in the Chinese embassy to the Philippine press. Though they tried to remain anonymous, it was very clear that they were using this to signal to the Philippine public the Chinese position. Acquiescence is what they demand. And this would basically be the surrender of maritime rights under coercion and duress, and now possibly through outright violence. At this time, as we speak, Harrison was describing the situation earlier. China is supposed to take the West Philippine Sea from the Philippines by the deployment of its constabulary and militia forces. They are ready to blockade approaches to all valuable reefs and low tide elevations in the South China Sea. Of particular mention was Scarborough Shoal, over which China has been exercising control since 2012. They are doing the same thing now with Second Thomas Shoal, surrounding the shoal with about at least 10 to 15 vessels at the time. And as we've seen, this week particularly, they even interfered with a simple medical evacuation of personnel on board. This is how China intends to take the exclusive economic zone and continental shelf of the Philippines, simply by blockading and preventing the Philippines' access to the valuable areas. For our fishermen, it is already having an effect. For the country, it is also seen in the fact that we now have very tight energy supplies. For the past summer, Philippine energy supplies the National Power Grid Corporation was on red alert due to the possibility of blackouts due to the very narrow margin between available supply and demand. And this is partly due to the inability of the Philippines to explore and exploit its own petroleum resources in the South China Sea, which it had been trying to do since the 1970s. Now, Second Thomas Shoal is of particular interest because it is actually a symbolic conflict. Nobody can see how a rusted, immobile ship, all alone in the middle of the ocean, could pose any threat to anyone. And yet, the attention which China has poured onto this particular vessel, this manned by a few Marines, is grossly disproportionate to the potential threat it can pose. This is because the stakes are actually very abstract and much greater and harder to quantify. For the Philippines, it is a symbol of sovereign equality. It is a symbol of its rights under international law, of its autonomy as a state, being entitled to the same rights and entitlements as any other coastal state. But for China, it is a symbol of defiance against its overwhelming power. It is about the 9-dash line, an excessive claim, which indicates Chinese preeminence and preemptive interests in the South China Sea, even if these interests trod upon the interests of surrounding countries. It is a challenge basically to the PRC, and that's why possibly China cannot tolerate its continued presence. Now, I had several points that I had arranged, but again, that earlier incident affected me. I think I'd rather put that's my third point up front now. At present, cognitive warfare is increasing with respect to the South China Sea. This vivid and personal demonstration of the impact of information operations was you've seen here very vividly. This cognitive warfare is seeping even into the legal discussions. Now, aside from the exploitation of historical grievances and presentation of economic ties as preferable, even though they come at the cost of sovereignty and autonomy, we see that the narrative against the Philippine-US alliance, for example, is ramping up, casting the alliance relationships as a legal issue rather than a political relationship. We've seen discussions about how the Mutual Defense Treaty does not actually provide any legal assurance to the U.S. Coming to the Philippines' defense of its interests. China is also exploiting the aversion to war by all the other parties by increasing the risks of operating within the South China Sea. And by doing, it does this partly by, it uses this partly to undermine, again, the belief in these instruments, such as the Mutual Defense Treaty and even AUKUS. China also continues to denigrate Philippine interests and positions as being the results of the manipulation of a puppet master, the United States, again vividly demonstrated this morning. And yet, at the same time, this clearly demonstrates that China does not even abide by its own 5 principles of coexistence, which includes supposedly the respect for sovereignty of other states. The constant propaganda by Chinese state media is in evidence. Anyone can look at Twitter today and see what the CGTN is saying about the Philippines and the Philippine-Alliance relationships, or even about UNCLOS itself and the South China Sea arbitration. China is attempting to relitigate the South China Sea arbitration war in the public discourse, despite the fact that it had every chance to do so when the proceedings were ongoing. It is also now demonstrating a belated concern for the environment, focusing on the micro effects of the BRP Sierra Madre, which has been marooned for a quarter century already on Second Thomas Shoal, and the effects of traditional fishing of small outrigger boats manned by people, ordinary people, not more than 4 or 5 per boat, while conveniently overlooking the impact of its own 300 to 400 ships that each day are moving around and mooring on the different reefs within the South China Sea. Thousands of industrial fishing vessels engaged in extractive activities, not only of fish, but also of endangered species and coral. So here what we're seeing is that when it comes to law, we see the undermining of the rule itself, law itself, through the lack of self-restraint, even on these matters. Now, moving on to another point, cooperation with ASEAN in this regard remains a challenge. Understandably, some members are held in thrall and fear of Chinese reactions. And right now, the Philippines is being used by China as a testing ground for possible future actions against the ASEAN claimants. Bilateral discussions with ASEAN claimant countries are now ongoing, and cooperation with Vietnam, for example, has been moving forward, and there are other discussions in the pipeline. When the earlier mention was made of ASEAN centrality and how this could still play a role, this is rather problematic when within ASEAN, number one, members do not see each other's respective interests in the bigger long-term picture. And also when their respective geopolitical interests are so wildly varied. It is within this context that the COC negotiations are ongoing. And what is happening is that you have an 11-sided negotiation taking place. That being said, ASEAN appears to be on track to finalizing a document within the next year or so. But finalizing the document does not necessarily mean that they have reached an agreement, because what is happening right now in this first, second, and third reading process that they have undertaken is simply basically an elimination of the non-starters, the proposed text that will obviously not be acceptable. And they're only reaching a point where they're agreeing on what can be discussed in the actual negotiations. Now, many of you are interested in the legal options that were announced by the Philippines, and it is indeed true, the case buildup is ongoing. However, the question is not when the case will be filed, but rather a more important one, which case should be filed first? Because the resort to legal options has admittedly led to a lot of rolling eyes, especially those who are more used to international relations and do not pay much value to the role of law and international law in the relations between states. Now, in the context of a primitive international community that we have now, without a sovereign being able to enforce rules, then legal options indeed might have limited effect, because they will not work without self-restraint and adverse consequences in response. No. But for smaller countries like the Philippines, we are invested in a community governed by international law. This should be understandable because it is within a community governed by law that all countries, regardless of power, regardless of economy or military numbers, that's the only place where they can be equal, when they can reach a mutually acceptable settlement of their disputes. The 2016 South China Sea Arbitration Award remains the foundation of the Philippines' positions on the West Philippine Sea. It's basically about its exclusive economic zone in continental shelf. It's basically about its access to resources to which the international community agreed it would have exclusive rights to and to benefit from. And yet this is precisely what is being undermined by China's actions. Earlier, the question was asked, why should states be using public international law in order to cast their claims? The question in response to that is, why? What's wrong with that? Community exists on the basis of agreed generalized rules. on the basis of mutual respect and equality, a resort to law is better than a resort to force or coercion. And it is better, certainly, than submitting to the unilateral imposition of the powerful. And I think that's where we are right now in the South China Sea. Thank you very much.
Thanks, Jay, for laying out some of the stakes. Chiting?
Thank you, Enrica. And thanks for the invitation from the CSIS for having me here again in this great conference. And when Greg invited me to here, also wants me to talk a little bit about Taiwan's South China Sea policies in the past 10 years, and also about our current new government's South China Sea policy. So I want to try to divide my talks into two parts. The first part is about like a retrospect for the past decade, and to put that as a context of this current Taiwanese government's South China Sea policies for the future. Yeah, so begin with the President Ma Ying-jeou's administration's South China Sea policy focused more on sovereignty, sovereign rights, and the interpretation of the regime of the islands under the law of the sea, due to Taiwan's international status and also the Taiping Island issue being involved in the South China Sea arbitration between China and the Philippines. And during President Tsai Ing-wen's administrations, the South China Sea arbitration award was announced, and whether Taiwan will comply with the arbitration and the United Nations Conventions on the Law of the Sea became an essential part of Taiwan's South China Sea policy debates. So, in the so-called 4 principles and 5 actions proposed by President Tsai are mainly about international law and UNCLOS, and also Taiwan's willingness to provide the regional public goods in the South China Sea. And in fact, President Tsai's South China Sea policy and the relevant statements issued by the Tsai government also gradually, directly, and indirectly responded to the broader U.S. actions to maintain a liberal international order, not just about the South China Sea region, but in the broader Indo-Pacific region. And so in the maritime domain, this includes at least like the U.S. freedom navigation of operation, and especially about the right of innocent passage, the legal status of the Taiwan Strait, and the issues related to strait baselines and marine scientific research, and so far. However, by the later period of Tsai's administration and the new administration of President Lai Ching-te, the liberal international order, including UNCLOS, faced more structural gray zone encroachment. Therefore, in Lai's inaugural speech this year, although he did not directly mention the South China Sea, he clearly referred to the gray zone threats as Taiwan's and regional strategic challenge. This was reflected in Taiwan's MOFA's statements opposing unilateral gray zone action, including near the Second Thomas Shoal by the Chinese Coast Guard. And so from the short time since President Lai's inauguration, it is evident that his view of the South China Sea shares many commonalities with the Taiwan Strait, from both legal and security perspective, which may form President Lai's overall South China Sea policy and also relevant to the Taiwan Strait policy, which could be integrated with each other and serve as a basis for Taiwan to cooperate with the regional states. And so in particular, there are at least, but not limited to, 3 commonality points can be made based on the recent developments. The first commonality is that both in the Taiwan Strait and the South China Sea face issues of different lines, encroachment made by China and further its own jurisdictions. So the lines here represent the coastal state's jurisdiction or the political status quo. So for example, in the Taiwan Strait, especially after the 2022 military exercise around Taiwan, the median line of the Taiwan Strait and Taiwan's restricted and prohibited water lines face challenges and pressure from China in both rhetoric and also Coast Guard or PLA actions. And so similarly, after the Kingman speedboat incident in February this year, China not only publicly stated that there were no prohibited or restricted waters line, but also dispatched Chinese Coast Guard vessels to enter the restricted waters of Kingman and Mazu. We can definitely see a lot of similar patterns already occurred in the South China Sea. And this also leads to the second part, second commonality points. So both in the South China Sea and Taiwan Strait, we can see that China also used the civil aviation flight path systems to influence the regional status quo. For instance, in the Taiwan Strait, the M503 route close to the median line and the activation of the W122 and 123 routes this year led to statements from Taiwanese government declaring this as unilateral changes to the political status quo without prior negotiations under the ICAO, ICAO. Similarly, in the South China Sea, we can see that Chinese military flights have flown over paths designated for civilian or commercial aircraft in ICAO-designated Vietnamese flight information region. And so for the third commonality point here is that both South China Sea and Taiwan Strait face a more comprehensive legal warfare from China. And I think that is the most important development right now. This includes not only new law or regulation promulgated by China, but also an emphasis on projecting actual legal enforcement capabilities in extraterritorial and disputed areas, also serving as a psychological deterrent to the coastal states. This may also destabilize the region and increase the potential for conflict. So let me maybe cite three recent examples here. The one is we know that the unilateral fishing ban enforcement action in the South China Sea has been imposed by China for many years. And the second example is like the second Thomas show. So the boarding and inspection actions against Philippine supply ships. According to China's provisions on admin law enforcement procedures of the Coast Guard agencies. And this also happened earlier this year near Kinmen's surrounding waters. And the third example is that in June, not directly related to the Taiwan Strait, but indirectly, China issued a so-called opinion on punishing according to law crime of splitting the country and incitement to split the country committed by Taiwan independence diehards, the so-called 22 opinions on Taiwan independence diehards. And this opinion, along with China's criminal law, authorized public and state security organs to issue arrest warrants if the suspect is overseas, potentially involving Interpol to issue a red notice. And so this represents another form of legal enforcement warfare with significant impacts on cross-strait relation. So in the three examples of the lawfare I just mentioned, that represent that China currently focuses more on how to materialize its claims through the legal warfare, or maybe we can call it legal enforcement warfare right now. So observing the above three commonalities I made here in the Taiwan Strait and the South China Sea, it is clear why Taiwan's current South China Sea policies focus on countering gray zone operations as a common ground in this region. And Taiwan's statements emphasize maintaining a liberal international order or maritime order accordingly. So these three commonalities in South China Sea and Taiwan Strait could help us understand that President Lai's remarks and also explaining Taiwan's important roles in regional security cooperations, especially on the gray zone. And it is evident that what happens in the Taiwan Strait may also occur in the South China Sea and vice versa. So I would like to stop here by this brief comment on Taiwan's South China Sea policy here, and thanks for your listening.
Thank you, Jiting, for outlining Taiwan's perspectives on the South China Sea and some of the legal sort of challenges and commonalities between what we're seeing in the South China Sea and the Taiwan Strait. So headed over to Aristio.
Right, thanks. Thank you very much, Andreka, and thanks, Greg, for inviting me to join these conversations on the South China Sea. I think conversation on South China is always important, and I think considering what happened in the past 6 months, I think it's make more timely discussions. So let me share several observations on the legal developments and the legal issues in regards to the South China Sea dispute. But let me start by drawing our attention a bit about the statement and remarks made by President Marcos in the latest Shangri-La dialogue, where he mentions a bit about the red lines or the international limitations on when Philippines will consider the act of China in the South China Sea as an act of war. I think he mentions, clearly mentions that killings, intentions or unintended killings to a Philippines Coast Guard or officials might be considered as an act of war. I think beyond a political statement, I think this is a very important statement which have quite a significant legal consequences in which when the law of naval warfare is going to be applied and the law of limitations between the law of the sea and the law of naval warfare. Under international law, of course, when the law of naval warfare applied, this is important to be noted because under the law of maritime neutrality, it's not only the conflicting parties, which might have any implications, but also the neighboring countries and how the ASEAN responds to if this kind of circumstances really happens in the South China Seas and whether or not ASEAN is ready for the implementation of law of naval warfare in a disputed area. I think one of the examples on why the ASEAN should be aware of and have strategies in responding to the kind of situations, because under the law of maritime neutralities, of course, is not only the conflicting parties, but also the neighboring countries, whether or not they're going to be neutral parties in the conflict or they're going to be involved in the conflict in naval warfare. Because under the Hague Conference, for example, that the war or the conflict might happen anywhere in the waters, only except in the territorial waters or archipelagic waters or the airspace of a neutral state. So, which means that the conflict might happen throughout the exclusive economic zones in the South China Sea. So how ASEAN should respond to this, I think it's going to be important and important not only for the conflicting parties, but also for ASEAN in broader sense. I think ASEAN has been long criticized by not having a clear strategies in responding with a time of crisis, but I think it's about time that ASEAN should have an honest and open conversations on what should ASEANs do when such a conflict or crisis appeared. For example, like a lot of criticisms on how ASEAN responds to the crisis in Myanmar, which not having an effective strategy. So I think it's about time that ASEAN should clearly outline what would be the options, what would be the channel of communications, what are the options on the table in responding to such a crisis. And of course, the other obligations which might also apply is how to ensure the freedom of navigations when such a conflict and crisis happened. Under the law of naval warfare and the law of the sea, passage through the strait used for international navigation, for example, in the Malacca Strait and archipelagic sea lanes passage remain important and should be secured by a neutral state. So I think that kind of conversations which we really need and ASEAN really need to have it right now. ASEAN has done quite a lot in order to prevent a conflict. ASEAN has organized a lot of workshops on managing conflict in the South China Seas, a lot of statements, but I think it's about time for ASEAN to not only thinking about the conflict preventions, but how to really respond if such a crisis happened. My second point is going to be looking at how to deal with the Chinese ambiguities in terms of like legal regulations. I think very recently, last month, again, China introduced an administrative enforcement procedure following up the ambiguous Chinese Coast Guard law, which now then legalized that China is allowed to detain foreign fishing vessels, which presumably illegally maneuver in what they call the Chinese jurisdictions. This, of course, have a lot of problematic because they're not referring to any maritime zones mentioned by the United Nations Conventions on the Law of the Sea. So what would be the Chinese jurisdiction? So we might want to see how this law is being enforced, but we can also expect that might be another more escalations happens due to this newly introduced regulation. So how to respond to this kind of ambiguity, legal ambiguity, I think it's very important for ASEAN state as well to respond to it. My last point, I think we talked a little bit about the code of conduct in the first panel, but I think from my perspective, I think it's about time that the ASEAN also be honest to itself that it's very less likely that we're going to be seeing the code of conduct agreed in the next few years. Based on my conversations with folks, negotiators in Jakarta, is that there's a lot of pending issues, whether or not it's going to be legally binding, whether or not there's going to be a dispute mechanism resolutions. But I think that one thing which people in Jakarta have a very different view with China is in regards to what Lynn mentioned in the first panel, is the geographical scope of the code of conduct, whether it's going to be applied throughout the 9-dash line, or it's going to be applied only legitimate claims under UNCLOS. So that is a place where diplomats in Jakarta think that it's going to be less likely to be, for example, Indonesia and China are going to be agreed upon. Because no way that Jakarta is going to be agreed that the code of conduct will be applied in throughout the 9-dash line. Because of course it's going to be recognizing something that is illegal under international law. It's not only dangerous for the international communities for agreeing something that is illegal under international law, but it means also that we recognized in overlapping claims between Jakarta and China, which we really don't want that to be happen. So I think that is three kind of legal issues which I thought is going to be very important to be observed in the upcoming years. But more importantly is how to anticipate if those kind of legal ambiguity and legal issues has really happened in the next few years. So I'm going to be stopping there. Thank you very much.
Thank you, Aristo. And I think we can all agree that ASEAN needs to be more proactive rather than reactive in terms of thinking through what the risks around the South China Sea are. Bic, I'll turn it to you to close out.
Thanks. Thanks, Entrika, for the introduction, and many thanks to Greg and CSIS for the invitation. It's good to be back. South Asian claimants have talked a lot about upholding international law, in particularly UNCLOS, but they haven't used UNCLOS procedures enough. So today I would like to talk about, why legal processes are a better choice than bilateral negotiation, which some countries prefer. And then I would, briefly discuss one of the main reasons why they haven't done so, and then offer some thought about how they can moving forward. So bilateral negotiation has worked sometimes, but I see three main issues with bilateral negotiation. So the first one is that it may not be final. So I'm thinking about the Gulf of Tonkin as a case in point. So in 2000, China and Vietnam have agreed on an agreement on the boundary in the Gulf of Tonkin. But then suddenly, earlier this year, China announced a Strait baseline. So with that one, the Strait baseline expand China's maritime zone significantly. And even though at this point it's unclear how that will affect the agreement between China and Vietnam back in 2000, but the implication is that with that line, in the future, China could pressure Vietnam to renegotiate. So because of that, it could be quite dangerous. And the second problem with bilateral negotiation that I can see is that it's quite tricky to reach some kind of statutory deal, solution between the two parties, especially when the power disparity is not large. Smaller states walk into the negotiation hoping that they can get a fair deal. But bigger states, they might feel entitled to get a bigger share, even though in some kind of symbolic terms. Bigger states may be unhappy with a fair share. But then if smaller states compromise and give just a little bit as a symbolic gesture to their bigger parties, then they could be seen as being weak by their domestic populations. So because of this dynamic, usually bilateral negotiation take many years, sometimes decades to reach conclusion. And people already talk about how long the code of conduct processes have been for many years. So by using legal processes, they can address the 3 points that I raised. So the binding, the rulings would be final and binding, and whoever loses the case will be less likely to be criticized for the result. If we look at the case, between the Philippines and China, for example, it took total only more than 3 years to reach the conclusion. So if China had been more cooperative, then the ruling could have come earlier. I think for countries like China, I think they could even get another benefit of using legal processes. Because Beijing has spent so much money on things like Confucius institutions and then media coverage overseas, trying to tell a good story about China. but their behaviors in the South China Sea has undone most of that. Last year at the Shangri-La Dialogue, when the Chinese Foreign Defense Minister told the Chinese line in the South China Sea, you could actually hear eyes rolling in the rooms because, everybody knows that China's word didn't match their action. So I think, by participating in legal processes and accepting the result in good faith, China could build their positive image a lot more effectively. So I think one of the main reasons why countries, the Southeast Asian claimants haven't used UNCLOS procedures as many times as they should, because there is some stigma around that. If you bring someone to court, it must be that you hate each other to the bones or something. So because of that, I think we should normalize the use of legal processes. So, Southeast Asian claimants, some of them have overlapping EEZs, so they can, agree to each other, take the cases to the court, in good terms. And after that, if China can see that, and, currently China has some reservations on 3 issues that they don't want to use UNCLOS. One of the 4 main procedures under UNCLOS to address, including the boundary delimitation, the military activities, and provisions under the United Nations Security Council functions. But besides these 3 issues, China can still agree to join other cases, especially under, the Annex 7 of UNCLOS. And it would be even better if in the future, China realized the benefits of legal cases and dropped their reservation under UNCLOS. So I really think that, countries like China can have a lot more to learn by using legal cases, legal processes. I stop here, thanks.
Thank you, Bic. And I think Bic's done a great job of capturing sort of the central thesis of this panel, which is that legal processes are important and we should be talking about them more. So we've got about just under 20 minutes on the clock. So if folks have questions here in the in-person audience, please feel free to line up behind the mics. For our online audience, please feel free to submit your questions through the CSIS webpage. I will sort of abuse my position as moderator and maybe throw out a first question. So Jay, I wanted to pick up on your discussion about potential future cases brought by the Philippines. So the Asia Maritime Transparency Initiative at CSIS has a really great website where they've tracked international support for the arbitration ruling back in 2016, tracking which countries expressed their support for the ruling and how that's changed over time since the ruling came out. So Jay, I'm curious to hear your perspectives on, in light of that journey, right? How is the Philippines thinking about international support, international engagement, diplomatic engagement, as it starts to think about what a potential future case might look like? And to the other panelists, I'm curious to hear your perspectives on how other partners and other actors in the region might respond to future cases lodged by the Philippines. So, how might Vietnam respond? How might Taiwan? How might Indonesia under a Prabowo administration respond to this?
Yeah, thank you. I think the fact that the Philippines is considering several cases is an indication of the value it places on international law, international processes. And again, this is a reflection of how it believes the international community should work. International support for these processes, in a way, is assumed because they were agreed to and were put in the treaties, and of course, as a sign of good faith in the implementation of agreements, the Philippines expects that countries will at the very least, respect its resort to these processes. Engagement with the international community, however, in terms of getting or gathering support for the Philippines, I think is something that is also being considered, because even if we're pursuing a legal process, inevitably there is an accompanying political process to that. No? And we saw, for example, with the first South China Sea arbitration case, that the Philippines did its job of pursuing these legal processes, but there were lots of questions and doubts. Even I myself was a skeptic at the time, but there were lots of questions and doubts on the part of the international community about where it will take this. No? And unfortunately, the fact that the case was won under a new administration, which had a very different take on China and China relations and the South China Sea issues, no, sort of became a hindrance to that. But I think now with the current administration, they have gotten back to the original strategy, which is to really pursue legal processes and rely on international law. Because as I said, the Philippines places a great deal of faith in having a community that works on the basis of these kinds of agreed rules. No? And despite disparities in power, size, economies, no? When it comes to certain basic issues like rights to the sea and access to its resources, it believes that a great deal of effort is already expended in settling that by negotiating the law of the sea, and therefore countries should, in good faith, pursue that and implement that arrangement. Thank you.
Yeah, I think that for the international cooperation or support, for not only about the possible litigations initiated by Philippines, but also I think the international law of the sea as a general. And so I think that for this region, or especially for Taiwan, I think the legal information warfare and also the legal campaign can be one of Taiwan's role here. And so, for example, what might be the distinctions between, just like Ariel said, that between the peacetime international law and especially the naval lawfare, and so that is about like distinctions about the gray zones. What is the hurdle of the use of force, and whether any kind of the specific actions could trigger or can be a violations of the UN charters of the prohibition of the use of the force. And also, there are so many maybe legal ambiguities in different domestic laws in these regions. For example, for the Coast Guard law, and also maybe about the maritime traffic law, and also other kinds of the measures. So I think this kind of the clarifications, and also maybe we can see this is a kind of the legal information warfare, can be a regional cooperations to support not only about the litigation, but also the, I said, liberal international order or the maritime order here. Thank you.
I think in responding to the questions on how Indonesia might respond to other judicial mechanisms, or what the dynamics in the South China Sea in general, I think there's a couple of things which might determine how Indonesia responds. The first one, I think it's our relationship with China, including the economic relationships, Indonesia with China. And the second one is like how we feel threatened about the China maneuvers in the North Natuna Sea. I think there's a couple of things which might very much determine how Indonesia responds. Let me give you an example, for example, how Indonesia responds to the 2016 tribunal's ruling. At first, Indonesia was neutral. Due to a lot of economic cooperations, President Jokowi with China, we're not really supporting the tribunals, not really endorsing the tribunals. But as going forward, we have more escalations in the North Natuna Sea with the Chinese Navy and Coast Guard. Then Indonesia has formally endorsed the 2016 tribunal's ruling. So I think it's because of we have a more threat than China. I think then we endorse the tribunal's rulings. Also, another interesting things to be seen is that how the the next president Prabowo responds and policies in the South China Sea. I think before he was a Minister of Defense, I think his statement is always clear that the South China Sea is one of the existential threat for Indonesia from foreign countries. He made quite a lot of strong statement, even in the debates, presidential debates. I think the other candidates have more arguments on operations and conversations, but he himself we have a strong naval capabilities in responding to the South China Seas. But then after he's being elected, and he as what Lin mentions, he went to China as the first country to visit, and his tone with China is more like in a softer and cooperation tone. So I think that is a couple of things which determines Indonesia's positions, the economic relationship with Beijing, and to what extent we feel threatened with China presence in the North Natuna Sea.
So I have 2 points. First one is that Vietnam has never ruled out the possibility of using legal cases and legal processes. And then the second point is that, Enrica mentioned the arbitration tracker. So from that, we can see that, initially many countries were silent on the ruling, and only later, many years later, they started to voice their support. So I think they could learn from that. They squandered an opportunity to uphold international law. So in future cases, I think they will voice their support much earlier.
All right, thank you. And I'll note that I think today is the 8th anniversary of that ruling, so we can all sing a round of happy birthday after this. So we've got about 10 minutes left, so we can shift to questions from the floor. I see we have a member of the audience here. If you would mind just repeating your name, your affiliation, and then make sure that your remarks are a question rather than a comment.
Okay. Augustus Alzona, Asian, Filipino, Catholic American male. My question is just briefly to whomever of the panel wishes to answer the question. It's up to you. In your personal and or professional opinion, what would you like the next Trump administration to do in terms of your issue, in terms of your personal or professional worldview? Priorities, briefly.
So let's frame that in the sense that, what are we looking for the United States to do, whether currently, before November, before January, and under the next administration? Yeah.
Okay, I think that what many countries in the region would like is that, if that happens, then the United States, we want the United States to keep the commitments that they have done. Especially, many progress has been done in this administration, and we don't want that to change just because another administration come to power.
Yeah, from my perspective, I think U.S. commitment in these regions has always been appreciated, and I think, but how to engage, I think it's another mean of stories. So, for example, I think Jakarta has got hugely benefits for cooperations with the U.S. Coast Guard, for example. We recently established the Joint Coast Guard Cooperations Office in Jakarta. Jakarta is sometimes going to be a bit sensitive with the extra-regional naval presence in the regions, but I think how the U.S. presence in the regions, more cooperations, more collaborations, I think it's greatly more appreciated than rather than just like sending like a freedom of navigations or so.
I think that the multilateralism is still a very important features for the Indo-Pacific region, and also a very important pillars for the maritime orders to be sustained. And I think that also maybe U.S. governments can provide like platforms to have a peaceful resolutions for these regions, and also like the commitment just as the other panelists said, I think that is as important as the legal warfare. Thank you.
I think I agree with all the rest of my panel. Its continuity is very important, regardless of which administration it may be. I think it's very clear as well that since we've been talking about reliance by smaller countries on the true international community, multilateralism, as mentioned, is also important, and we hope that the United States continues that policy of promoting multilateralism and resort to these mechanisms such as international law. Because in the end, it's only through this that we can really find a stable and peaceful community. Thank you.
Thank you.
Thank you. All right, so we've got about 6 minutes left, so I'll take a question from the floor, and then I'll also read out a question that we've got in online, so we can answer both questions this round. Ben?
Thanks. Ben Bland, I'm the director of the Asia program at Chatham House, a think tank in London. I just want to ask about the impact of the Israel-Gaza war and Russia's invasion of Ukraine, specifically with relation to international law. So all our countries have had very divergent responses, including legal responses to these two conflicts. How do you think that might affect the legal dynamics of the South China Sea? Thanks.
Thank you. And I'll throw in this question that we've received online from Maritime with RFA. Maybe I'll toss this one to Jay and Bic, but the question is, do you believe the Philippines and Vietnam can cooperate to protect peace in the South China Sea? So we have a question on Israel-Gaza and the impact on the legal space, and a question on the Philippines and Vietnam cooperation.
Okay, with respect to the Israel-Gaza war, I think it has affected the legal dynamics in the sense that it has become one of the key battlegrounds in the cognitive warfare that's going on. As I mentioned earlier, discussions over the South China Sea about the role of foreign powers like the United States, the Agency of States, and the usefulness of resort to these relationships that we have. These have been the subject of much discussion and contestation now. We see it in social media and even in the formal traditional media, we've seen that. So the Israel-Gaza war has played a role in that because it, in a way, has become one of the key arguments to cast doubt, for example, on the rules of the United States and the righteousness of states' positions. So I think that is playing the role. We don't see yet any particular trend, but it's certainly adding to the complexity in the discussions. As to the second question, the answer is yes, because I think one thing that most countries have certainly overlooked is that despite the existence of disputes between the Philippines and Vietnam, and despite incidents having taken place between the Philippines and Vietnam, relations have remained to be stable and good, and they have been improving even. I believe actually that Philippines and Vietnam present the actual model, the real model for how the disputes should be managed and ultimately settled in the South China Sea. We've had exchanges even of personnel between our respective current positions in the South China Sea. We've had continuing cooperation in terms of economics and in political relations. And so I think this is really the way by which all of the countries, including China, should be dealing with each other with respect to their disputes in the South China Sea. Thank you.
I would take the first questions, and I would understand the first question is how the Ukraine's wars have the impact on the international law. And I would say that the first important thing is that how to still maintain the prohibition of the use of force and how it applies to each situation, including the South China Sea and also the cross-strait relations. And also, I think that there are several loopholes and also ambiguities we should have to bear in mind, like what we just mentioned about what can trigger the threshold of the use of force. And also, we don't know what is the cyber law is, because we know that is lacks in the international law. So maybe it is time for us really to know how to form those cooperations, those ambiguities, and also the domain which maybe we need more legal regulations or the legal institutions. So that is my quick response.
Just a quick response to the first questions. I think it's more or less, of course, have an impact to Indonesia for a couple of things. First, about the commitments of the United States towards international law. I think it's not only affect the public perceptions towards the reliable of the United States as an ally, as a partner, but also like the government. I mean, like Prabowo in his recent statement is also have quite a strong statements against the West countries, including the United States, vis-a-vis on how they respond to the wars in Gaza and how the U.S. committed to a rules-based international orders has been repeatedly, but how the commitment to the rule of international law, I think it's also been questioned by Prabowo himself. So I think that is more or less have an implication on how they view the partnership with the U.S. and the commitment of the United States towards international law as a neutral countries.
So on the question about Vietnam and the Philippines, I agree with Jay, so I don't have anything to add on that. But to Ben's question about the two conflicts, I think that many countries have responded to the two conflicts differently based on their own calculation and interest. So that's very not consistent. Yeah.
All right, thank you. So I'm being told that we are at time and we have to leave you out for lunch. I don't know about you, but that was a fascinating session. I've taken like 4 pages of notes here. So just want to thank all my panelists here, give a round of applause, and thank you for joining the second session.